Hello and good morning and good afternoon to everyone joining us today on our next Fieldfisher Silicon Valley privacy technology webinar. I am Mark Webber. I'm the US Managing Partner out in California, and I'm really pleased to be joined today by Robert Fett and Andrea Ortega and Megan Ward, all on our privacy team, all based in the US, some dual qualified, some EU, UK qualified, and bringing you some insights and practical perspectives on one of the common issues that we're talking to a number of our clients about, this issue about using AI or machine learning for product improvement. So AI ML, as we'll be referring to it, and talking a little bit about where the market is headed and what some of the practical and commercial issues that are coming out for individual clients and vendors and customers that we're working with. So we're going to have a look at the legal landscape, and Rob will take us through a little bit of that, and then introduce a bit of a case study to bring some of this alive. We're also going to think about what options vendors have and how they can construct rights to learn from data and reserve those rights in their contracts and then do it within the law. But also have a look at a bit about where the market is headed and the general direction, particularly with some UK and some EU legislation looming around AI, although I think I'll say that there's going to be a little while yet, and a lot of that is going to be within a common framework. So we're just going to then finally wrap up with some practical steps for implementation and kind of talk through some of that. So we're really in a world where this legal landscape is difficult, and actually there's been an evolution, and I think the theme of today will be that evolution. There's an evolution in general technology. What you can do today is, quite impressive compared with what you could do in 2017 or 2016 before the GDPR. What businesses all do in 2 or 3 years' time is even more impressive and even more technical. So we're having a journey, this evolution in technology, which is making us think and think again. Alongside that evolution, as ever, the law is trying to catch up with technology, and we're also seeing an evolution in law and an evolution in practice. And we've seen that from GDPR being implemented, where pre-GDPR, people didn't necessarily think about some of the AI or ML they were doing or what role they had. We've seen increased guidance. We've seen some quite specific guidance from the French CNIL, which we'll introduce you to. But we've also seen an evolution in practice. There are a lot of SaaS companies and a lot of businesses out there looking to drive insights with AI. Sometimes that's providing enhanced product, or sometimes that is the underlying product. Other times it's gleaning little nuggets, information or analytics which could be used to inform and to improve the product or enhance services going forward. Now and again, some of these things that when we're interacting with a SaaS product or online, some of these intelligent steps or some of these personalizations or some of the intuitive design which is coming through is powered by AI and ML, or more ML, I think, and that's really powerful. But as a part of that evolution, we're all growing up in a legal market and finding, I think, more and more 2 genuine things. One, we have to understand the way the machine learning is taking place and what data is involved, because if we don't understand that, we can't comply. And then if we're a vendor, if we don't understand that, we can't justify and build trust with our customers to explain why we're using data and why it's okay. But that dual role and those extra underlying obligations under data privacy and GDPR, UK GDPR, put extra burden on businesses that use personal data and leverage that personal data for that learning and for product improvement. So with that early introduction, we're not going to go too deep on legal, but we, of course, as a law firm and a legal webinar, we have to go somewhere. So Rob, why don't I hand over to you for an introduction into the legal issues?
Thanks, Mark. So to work through the issues of using your customers' data for product improvement, we're going to use a case study. But before we dig into that, let's have a quick recap on some of the GDPR issues. Well, the first question to ask is what data will be used for product improvement? since protections in GDPR only cover personal data and not anonymized data. As you'll know, pseudonymized data is also personal data and protected by the GDPR too. Now you might be thinking, well, hang on, let's just anonymize all the data and use that for product improvement. Well, notwithstanding the question about whether that would actually be useful, there's another caveat. Even if the data you are using is anonymized, and that is quite a strict test to meet under the GDPR, and a question which could take a whole webinar in itself, the process of anonymizing the data is itself an act of processing under the GDPR. So you'll need to consider your obligations in that regard too. So let's talk about some of these issues. Firstly, transparency. A party that is processing personal data as a controller should give notice of that processing, but who would be included as controllers for that purpose? Well, firstly, there's going to be the customer. If you're sharing unanonymized personal data with the vendor for the purposes of product improvement. Secondly, the vendor should also give notice that it is processing personal data. That notice by the vendor would include notice about any anonymization involved, and even if not anonymizing, notice about the ongoing processing for product improvement. Regulators have also suggested, and although it's not a strict legal requirement, that vendors may also want to disclose how they are processing anonymized data for product improvement, as that could increase trust with the data subjects. Now, there are also practical issues around providing that notice, depending on who, if anyone, has a relationship with the individual data subjects. For example, it might be the customer that has the relationship and not the vendor. The second issue to think about is legal basis. So as we know, any processing of personal data, either for anonymization or the ongoing processing for product improvement, must have a legal basis under Article 6 of GDPR. Now, legitimate interest is usually the way to go for that. However, if special category data is involved, for example, health data or biometric data used for identification, then there is also a requirement to satisfy a condition under Article 9 for that special category data. And that could prove more difficult because explicit consent is often the only option really available. And practically speaking, this would need to be obtained via the customer who has the relationship with the user. The third issue I'm going to mention is the contractual obligations between the customer and vendor. So if the vendor is anonymizing the data or using that unanonymized data for product improvement, the question arises as to whether it is permitted to do so under its contractual obligations with the customer. As a processor, the vendor is required to process the personal data only on the documented instructions of the controller. That's the requirement that comes out of Article 28 GDPR, and hence will be in the data processing addendum between the vendor and the customer. Now, assuming the customer is willing to agree to this additional use of data for product improvement, there's some guidance from the French regulator, the CNIL, which came out earlier this year, which also requires that the customer conduct a compatibility test to determine whether the processing for product improvement is compatible with the purposes for which the data was originally collected. And this requires finding a link between these purposes, along with some considerations around the consequences for the data subjects who are involved, for example, around their data subject rights. Now, finally, as we've discussed in previous webinars, the use of AI and ML raises some interesting questions about who the controller is. And that will depend on the role the customer and the vendor play in, for example, setting up the model, who's selecting the data, and the data used to train and test that model. We won't go into those issues deep in this webinar. Now, the complexity and practicality of some of the issues I've just mentioned has in the past often led vendors to bury their heads in the sand. For example, quietly using the data for product improvement without providing notice to either the controller or the data subjects, or even concluding that the use of anonymization techniques basically voids them of any responsibility at all. However, recent guidance, such as I mentioned from the CNIL, along with some more sophistication from customers who are becoming aware of such activities and who are also not wedded to the idea that all their vendors must always be processors, means that the sands are changing. Andrea and Megan will go on to explain the options vendors have to navigate these issues and how to practically implement them. But first, we're going to take a look at a case study, which will be the basis of that discussion. So Ostrich Corporation is a vendor providing analytics to its customers about how their sales reps generate leads and close deals. It has a core product called Big Egg, which acts as an email solution for the sales reps to help them keep in contact with leads. It also generates visual analytics for the managers of the sales reps to help them understand how the deals are progressing, and it reminds the sales reps to follow up with their prospects. Now, Ostrich already analyzes sales rep use of this program to understand how the features of the product are used, for example, how often and for how long the sales reps log in, which buttons they click on. These are all fairly benign uses of data from a data subject's perspective, and of course, often these sort of uses are done on websites as well, and the data is pseudonymized. But Ostrich has done some analysis, included that it does not reach the standard required for anonymization under the GDPR. Ostrich doesn't currently analyze customer content, such as messages sent between sales reps, managers, and their prospects. And all customers benefit from the improvements which are made, which will help speed up the product and improve the design. Now, up until now, Ostrich has been taking a risk-based approach to its privacy compliance, not unusual. And Ostrich's standard data processing addendum positions Ostrich solely as a processor and has no provisions for Ostrich's use of customer data for product improvement. Neither Ostrich nor its customers provide any notice to users about the usage of this data. But now Ostrich is launching a new product called Faster. Faster will use AI to analyze customer content, such as emails to customers and internal messaging. And the idea is that this new product will help sales reps to quickly and automatically generate emails to follow up with their prospects, which are tailored for the particular customer and the particular deal they're working on. And customers are going to find this really useful. They hope this will help them to speed up the closing of deals. And there's also going to be some cross-client analysis on Ostrich's part of all of this data to help improve the product feature for all of its customers so that they can generate these quick emails and it will be very efficient. Now, what's Ostrich's risk tolerance? Well, it wants to make its life easy commercially, of course, and it doesn't want to enter into arduous negotiations with its customers about DPAs. It has a very small legal team and really not much time for that. But it also doesn't want to get dragged into investigations by privacy regulators, and it's also not aiming for a golden egg standard, forgive the pun. So what options does Ostrich have? For the purposes of this webinar, we're going to focus on the issues I set out earlier. We're not going to delve into e-privacy issues around confidentiality of communications. So over to you, Andrea.
Thanks, Rob, and hi, everyone. I'm going to try to be as practical as possible here. So for instance, I'm not going to go into the details of what it means to be a processor or a controller, or specifically what the existing guidance states or what potential fines could be faced, among other things. We've addressed some of these related considerations in other webinars that you can find in our YouTube channel. Note as well that we are also going to be focusing on the perspective of the vendor, not the customer. So to summarize the case study that Rob has introduced, Ostrich initially processed usage data for its own business purposes, mainly to understand how its customers use the products and features and for product improvement purposes, and now wants to start to use and process customer content from multiple customers to create a specific new feature. As we will see, either of these activities will likely result in Ostrich fulfilling a controller role. And to start the analysis, I think it's important to clarify the difference between, on the one hand, the data used to train and test the machine learning model, and on the other hand, the machine learning model itself, which is a common question we have. So a machine learning model is software or algorithms trained and tested on data. It is therefore not itself data and not subject to the GDPR, which means that, for example, there's no requirement under the GDPR to provide access to or delete a machine learning model. We are therefore focusing here on the implications of using the personal data itself. So now moving ahead, so based on existing guidance, the perception of European and UK supervisory authorities is the following. So firstly, The perception is that the use of machine learning for product improvement that benefits the service provider or other customers of the service provider is implicitly a controller activity. Secondly, they lean towards considering that consent from data subject is required as the legal basis for processing, among other controller obligations. And thirdly, that achieving anonymization is especially challenging here. It's worth noting that some of this existing guidance refers specifically to virtual voice assistants, which in many cases will constitute a business-to-consumer activity. And many cases, including the one in our case study, are business-to-business scenarios. However, we think that this alone will probably not change the perception of supervisory authorities that machine learning for product improvement is a controller activity and requires data subject consent. And the rationale behind this is that, for example, the vendor will be selecting from among its customer content in the case of the new feature, the data it considers necessary to train and test its ML models. It will also determine what the model is aiming to achieve. That's the purpose of the processing. And it will select also the algorithms used for its ML purposes. So ultimately, it will no longer be acting on the instructions of the customer. In contrast, an AI service provider that's isolating different client-specific models and only enables its client to make decisions based on their own model would be able to maintain a processor role. If this isolation is not maintained, then you're likely stepping into a controller role in the eyes of the regulators. And in the case of Ostrich, it looks like here, Ostrich wants to use and process the customer content from multiple customers to create a specific new feature. So it will be determining the purposes and means of the processing, and there will be no isolation between the customer content in principle. So this will likely imply a controller role. Note that ultimately this is a question of fact, so the details here are important. Remember that contractual documents may seek to allocate roles and determine the position, but neither regulators nor data subjects are bound by by the contractual positioning. So if in this case and was assessing all the relevant considerations, Ostrich concludes that it fulfills a controller role for these processing activities, Ostrich will have to decide as the next step what approach to take. And there are several options here, and this include the following. So first, and if you can pass on to the next slide, please. First, Ostrich could decide to maintain its existing processor position in its DPA and make no disclosures in its customer contract or privacy notice about its controller uses of the data. And this would mean proceeding at risk and hoping not to be caught. And second option would be covering the relevant processing activity as a controller in its public-facing privacy notice, but remaining silent to the customer. This would be more compliant and allow the vendor to maintain that it has disclosed the controller use, even if not in a way that is particularly transparent to the customer. And some customers may review the provider's privacy notice and take issue with its controllership status. So that's something to consider. Other options are explicitly acknowledging the controller role, in particular in the customer contract, in the DPA, including considering addressing joint controllership issues where relevant. And another option is implicitly acknowledging the controller role. So for example, in the DPA, as we were mentioning, by having the customer authorize its intended uses of the data, but without expressly calling itself a controller. And in this latter case, some customers may spot this issue and refuse to authorize some of the provider's intended uses or insist on more detailed data protection language being added to the terms in the DPA. So there are really pros and cons to each of these options. Obviously, factually, the determination would be a controller role. Maintaining a processor positioning implies taking on legal compliance risk. Note as well that the likelihood of the legal risk crystallizing is higher in the C2C context in contrast to the B2B. And this is because the processing in the B2B context will largely be invisible to data subjects and to regulators, unless the results of that machine learning in some way obviously intrudes upon individuals' private spheres. So for example, by targeting them with personalized messaging or similar. In addition, there's trade-off to be had between legal and commercial risk. There are also, so in addition to those options we were discussing, there are also risk mitigation measures that can be considered, particularly if the vendor decides to maintain its processor role. So this would include, in the case at hand, limiting the use of customer content for machine learning purposes only to specific functionality used by the customer, to be able to argue that the processing is for the benefit of that specific customer, or avoid using machine learning to create products, services, or functionalities that target users with highly personalized messaging. Finally, another risk mitigating measure would include de-identifying the data used for machine learning purposes. The ideal objective here is to completely anonymize the data, at which point it would fall outside of the scope of the GDPR and can therefore be used freely. Remember, however, that as Rob was mentioning, under the GDPR, the act of de-identifying or anonymizing is itself a processing activity, and therefore you would need to comply with data protection requirements for this processing. So, for example, by having a lawful basis and providing notice. And further, as noticed previously, it's very difficult to achieve successful anonymization under the GDPR, as opposed to pseudonymization, and pseudonymized data is still personal data subject to the GDPR. Finally, in addition, note that anonymization may in some cases reduce or even eliminate the utility of the personal data for the provider. So that's also another consideration to keep in mind. Now, having assessed the options and some of the risk mitigation measures, in terms of where the market is headed and what we're seeing others do, what we are increasingly seeing is B2B SaaS providers acknowledging in customer contracts their controller role for product improvement purposes, and also in some cases in public-facing statements. And this includes, in some cases, usage data, and in others, customer data. The public-facing statements tend to explain they provide opt-out options at either the customer level in the form of kill switch functionality, or at the end user level, or both. What we are not seeing in the B2B space is many companies obtaining opt-in consent. I mentioned earlier that supervisory authorities lean towards considering that consent from data subject is required as the legal basis for processing. But as I mentioned, it's likely more rare to find opt-in consent within B2B products, and there's more risk taken with an opt-out approach. It's worth noting here that where an opt-in is provided, the vendor will not use the data unless its customers or end users have authorized it. Therefore, arguably, opt-in could be part of a controller or processor positioning. So depending on how things are structured, an argument could be made that by giving this authorization, customers have instructed the vendor to undertake the processing for ML purposes as a processor. By contrast, relying on customer opt-outs is much more indicative of a controller role, because the vendor has clearly decided to use the data for machine learning purposes unless its customers object. In addition, the absence of an opt-out does not conclusively indicate that a customer authorizes or instructs the processing. Instead, it may simply be that the customer did not read the terms properly and so did not see the opportunity to opt out. So to clarify these points, and purely from a legal perspective, the use of the data for machine learning purposes is highly likely to result in a controller determination, regardless of whether an opt-in or an opt-out are offered. In terms of recent legal and regulatory developments, it's worth noting that there's recent guidance from the CNIL, as Mark and Rob were mentioning, on additional conditions to be satisfied for the lawful reuse of personal data as a controller, where it is obtaining a controller-processor relationship. And these additional conditions include conducting a compatibility test to determine whether the purpose of the processing will be compatible with the purpose for which the data was originally collected by the customer. Secondly, obtaining prior written permission from the customer. Thirdly, the initial controller must inform the data subjects about the subsequent uses of their data by the processor. And the processor, now as a separate controller, must inform the data subjects about its own processing activities. In particular, in particular, this latter can be problematic as the service provider now has obligations to data subjects that it has in many cases no direct relationship with, as Rob was pointing out initially. The CNIL suggests greater cooperation between controllers and processors will be necessary going forward to address this. But in any case, this is quite new, and we'll have to, keep watching the space and see how this guidance will influence other data protection bodies as well in their consideration of these issues, as well as where the market goes. Finally, I wanted to mention that the biggest development in Europe on the subject is the proposed legislation laying down harmonized rules on AI, the so-called European AI Act. The approach here is to establish a risk-based regime. It will prohibit the perceived most serious threats, introduce risk management controls on less serious but still high-risk AI systems, and put transparency requirements in place for others. It will also seek to put measures in place to support innovation and to encourage the development of voluntary codes of conduct for AI generally. There are also big fines for non-compliance, and this will include failing to demonstrate compliance with the new requirements and the new law. Though, as Mark was mentioning at the beginning, it will be still a while until the AI Act comes into play. And for further insights into the AI Act, I'd recommend you listening to our last webinar addressing it. So that's all for me. I hope this was helpful. I'm going to pass it on to Megan, who's going to share some insights in establishing a framework to assess AI systems and establish the necessary measures and protections under the European regime. On to you, Megan.
Thanks, Andrea. Yeah, we thought it would be helpful to end with some building blocks for implementing an analytics framework. And you could also use these as a checklist when presented with a new analytics use case. So firstly, which we've talked about extensively, is know the data. Consult with the relevant teams to find out exactly what data is in scope. Is it personal? Is it pseudonymized, which will also be personal data? Or is it truly anonymized? And where will the data be collected from? And the method of collection, will it be server side or will it be from end user devices? Ensure you're only using the minimum amount of data for the intended purpose. And if there is any more than that, you shouldn't be collecting it. So if we think back to Ostrich Court, we're looking at login session time and frequency, which features a user interacts with most, and clickstream data. As Rob said, it's fairly benign data, but still personal, even though it's pseudonymized. Second, understand the purposes. So will the data solely be used for product improvement? And will that be for product improvement across the services as a whole for all customers' benefits, like in Ostrich's case? Or will it be restricted to improving a specific customer's service? Once you've identified the purposes, going forward, monitor the purposes you've identified as the program develops. This is important as it will help you watch out for scope creep, and it's important to regularly review the roadmap with the relevant teams for any new use cases. This review process all goes towards accountability. Also communicate to the business which purposes or use cases are permissible versus those that are strictly off limits. And you may also have an in-between category for that. So if there are some that are that are sort of gated and require approval before teams can go ahead. So for example, an example of a off-limits use case could be don't share the data with third parties except for the limited analysis that's provided by certain service providers. Next is ensure legality of processing, and we've talked a fair bit about legal basis for processing already, but in each instance make sure you can establish a legal basis for the collection and subsequent processing of the data. If special category data is involved, you'll need to identify an additional condition for processing, and explicit consent is most likely the only option here. Ensure choice and control. What choices you'll offer and which privacy controls you'll implement will be different in the context of customers or end user level. Ideally, you should offer both, and Andrea mentioned some of these already, but offering an analytics opt-out or kill switch is an important feature that will not only help to support and justify the analytics under the law, but it also builds trust with customers. In addition to that, can you offer customers more granular controls? So the ability for a customer to opt out of analytics being used for a particular purpose, for example, marketing. And ideally, you would also give end users the ability to opt out in product, as well as clearly signpost how the user is able to do that. And finally, on that, on a sort of related point, ensure you can honour all data subject rights. So within the data set, do you have the functionality to search and find individual users in the event that a data subject submits a data subject access request? And are you able to give effect to data subject rights? Are the technical controls in place to say delete a particular user's data? 5, we've got ensure transparency. How will you provide customers and end users notice about how the data is used for product improvement? And your approach to this will depend on which option you go for, as Andrea discussed earlier. Will that be disclosures in your privacy notice related to your controller role but remain silent to the customer? Or will you explicitly acknowledge the controller role in your contracts and privacy notices? And finally, ensure sufficient safeguards are in place. So if we think about data retention, only store the data for the minimum period of time in order to fulfill the purposes that you've identified. And implement access controls to ensure the data is locked down to only the teams who need to use it for the specific purposes you've identified. This will help prevent scope creep. I think, so that's it from me. Yeah. In terms of questions, if there are any, I can't see that we've got any so far, but if there are any, please do reach out to one of us after the webinar.
Thank you very much, Megan. Fantastic sort of insights there from the team. But just before we come on to what we'll be doing next, let's just sort of look back at what we thought about. I think it's, you know, it's clearly a complicated topic, not least because the technology is complicated, let alone the legal analysis that you put against that. And of course, there's some optionality, as Andrea, who was talking us through, and then some obviously best practice to overlay against that when you're practically implementing some solutions, as Megan was kind to say to tell us. So I think it's somewhat easy to talk about risk taking, to talk about coming out with a view, but of course, as with many things privacy, your view or what works commercially for you may not work for your customer. And the one thing to remember when you're designing this, particularly if you're a vendor looking at this from a vendor perspective, is you can come up with all of the analysis you want, but you really need to be able to explain it, just as I said at the beginning. Trust by customers, trust by those end users whose personal data is being used, their data subjects are impacted, really matters. So the ability to explain and build that trust is everything. And then what you will find is you do need to explain to your customer or to the end user, or to justify, or even, you know, step in and maybe one day talk to a regulator about it. Having that understanding is key. The final thing I will say is what we find with all of these things is you really need a program. It's not enough to do a one-off analysis when it comes to this kind of learning, because of that evolution and because of the evolution I mentioned at the beginning. We do see technology change. We always see scope creep. Almost as fast as the policy's been drawn up, somebody wants to do something else, or a new arrival has got a new idea, or there's a new product doing something else and you need to revisit. So being aware of what you assessed and what you felt okay with 1 month may not be the same as, you know, the evolution in product and what you may be doing in the future. And then looking at the way those incremental changes can then impact and make changes. Something you were comfortable taking a small risk on day 1 maybe changed in month 3, changed again in month 6, and by the time you get to another incremental change, yes, it's a small change, but in combination with the changes in month 3, month 6 and month 9, you've suddenly got a very different outcome. So scope creep and monitoring that and having a way to deal with that, having the business and others come and let you know what they're doing when you're in that vendor role, all important, and an important part of accountability and having the right kind of policy management for this kind of AI ML product improvement program. So thank you very much to the team for sharing insights. We wish Ostrich Company all the luck in the world with this latest rollout. We'd love to see you again. And next up, we're doing an overview of digital advertising. That's going to be on the 10th of August. Look out for invites soon. I think you'll hear from some other colleagues on this one, but we thank you for joining and spending some time with Fieldfisher Silicon Valley today, and wish you all the best, and we'll catch up with you soon. If you have any questions, you know where to find us. Thank you.